Hello and good afternoon. I would like to welcome everyone to today's webinar, The Definitive Guide to H-1B Alternatives. Thank you so much for joining us this afternoon. And before we get to the main presentation, as always, just want to go over a few housekeeping items. The presentation today is being recorded, and all attendees will receive a link to download the recording. You will also receive the accompanying slide deck, as well as SHRM and HRCI continuing education credits. All of these materials will arrive in a follow-up email tomorrow afternoon, so please keep an eye out on your email inboxes for that. And if you don't receive the message, please just let us know, and we'll be sure to get it over to you. Additionally, during today's presentation, we encourage you to ask some questions. You can do so using the question feature via GoToWebinar, which you should see on your screen. Type that question in, and we'll try to get to it at the very end of the main presentation. All right, so moving along, for those that are unfamiliar with Envoy, for nearly 20 years, Envoy has been on a mission to fix the inefficient, frustrating, and confusing immigration process. Envoy combines expert legal representation with innovative technology to deliver the only platform that makes it seamless for companies to hire, mobilize, and manage a global workforce. Envoy secures work authorization in over 100 countries, has grown 37% year over year, and works with over 1,000 customers. We are particularly proud of our NPS score, which is a testament to the employee experience that we provide. And joining us today for the presentation, I'm excited to welcome Sarah Herbeck, the Managing Partner at Global Immigration Associates. Sarah provides strategic immigration advice regarding movement of professionals throughout the world. She oversees over 80 attorneys, paralegals, and support staff. She graduated with honors from Northwestern University and received a JD from Chicago-Kent College of Law. Sarah, thank you so much for joining us this afternoon.
Thanks for having me, Eric.
Great. So before we get to the main presentation, just a quick overview of today's agenda, starting with high-level overview of the global talent landscape, briefly discuss some policy updates, recent ones, and then move into the visa alternatives. And as I mentioned, we'll end with questions. All right, so let's hop into things, starting with today's global talent landscape. And we're going to start off with some recent numbers from Envoy Global's newly released Immigration Trends Report, which is available to download now. We surveyed over 400 HR professionals and found that 85% of employers expect their foreign national headcount to increase or stay the same in 2020. This is a result because, as we see at the top, according to the Bureau of Labor Statistics, there are approximately 6.4 million unfilled jobs going into January 2020, and only 5.8 million unemployed persons. And this gap has existed for nearly 2 years, 2 consecutive years, that is. Sarah, another interesting stat here that I want to discuss, and we're seeing is case processing times. Here, there in the bottom left, Ayla, they said the average case processing time has increased by 91% since fiscal year of 2014. And this is going to lead into the next slide, but I'm just curious, is there a reason why it's taking USCIS longer to process cases, and how is that affecting employers?
Right, so it is directly related to the number of requests for evidence that are being submitted, so that just adds on significant additional time and work for both attorneys, clients, their employees, and USCIS. And so it just takes longer to adjudicate the case. And as a result of that higher volume in RFEs and the like, we're seeing a longer adjudications process. Now, that's not to say that there aren't other contributing factors, but I think that's one where we can actually see the trend based on publicly available information published out of USCIS to show there's a direct correlation.
Gotcha. And has USCIS made any attempts to lower the processing time?
They've not, but they have been called out on numerous occasions, both within Congress and AILA, as stated, in indicating the long delays. To your second point of the question, which is how does that impact employers? Well, we see, when available, in particular in H-1B change of employer circumstances, given the long adjudication timeframes and just the heightened level of scrutiny and also the heightened level of nerves within the foreign national population that are, say, changing an employer, there's an added expense there. So you're seeing an added expense for premium processing for that adjudication, or at least that update within 15 calendar days. And there's also obviously an added cost when there's a request for evidence. So those take time. And depending on the strategic approach as determined by the immigration attorney, can cost, a significant extra amount of money. Right.
Great. So thank you for explaining that. Then moving along, also just wanted to discuss with our attendees just the impact of recent policy changes, and which is going to lead into some alternatives, but the alternatives we will be discussing. So the two that we want to highlight, we'll start with H-1B electronic registration. I know those might be three of your favorite words lately, but we discussed this in greater detail earlier in the year, and as I understand, electronic registration opened up March 1st.
It did, March 1st at noon Eastern.
And how's that been going so far?
So far, so good. We are halfway through. It closes March 20th at noon Eastern, and the system so far works. There is an additional coordination between our clients who are going through and verifying and ourselves, but we are seeing it work. So our hope is that it will continue to work, it'll close out, and USCIS's intention will be fulfilled such that hopefully by March 31st, we're going to know whether or not a foreign national employee has been selected, has not been selected, or is sort of being held to see whether or not, after the CAP process is completed, if there are still visas available. So far so good. We still have about 9 days left, not full days, but say 8.5 days left. So we are cautiously optimistic.
That's a good way to put it.
That everything will go forward as planned.
Okay. Good to hear. And then the other policy update I wanted to ask you about is the public charge rule, which in late January, the Supreme Court allowed it to move forward. Can you just kind of briefly discuss this rule and the potential impacts?
I think at the end of the day, what this is ultimately going to do, and the biggest impact will be on the employees.
Okay.
Because there is a lot of financial information that will be required to move forward. It also adds an extra layer of uncertainty because there is a lot of discretion with USCIS officers as to whether or not they are going to prospectively be a public charge or rely on public benefits. And so it is going to be, it's just sort of, again, another added layer of scrutiny. So I think the direct impact is going to be the employees, the foreign nationals who are applying for their green cards. Not only from a nerves perspective, but from a time frame perspective. And I said this before, and I will continue to say this, the immigration process is quite invasive. You don't normally go to the doctor and hand over your medical records to the U.S. government, right? It's not something you or I would never consider doing that. So there's that, and it's just a part of the process. Well, this is now even more. Going into assets, liability, family members living with you. I mean, this is a lot of information that is being collected and is now required. So you are required to disclose this information to USCIS. And so it's going to be an added situation where there's likely going to be more conversations. There is going to be, again, more scrutiny out of USCIS. So right now, we'll kind of watch as they are being adjudicated, but again, the foreign national green card applicant is going to bear the brunt of this.
Gotcha. Thank you for discussing these two recent policy updates. For our attendees, we'll kind of recap everything that's happened in Q1 at the end of March in another webinar. So please sign up for that for additional updates. So we're gonna move on to H-1B alternatives, which, as you mentioned, the electronic registration, and for those who may not get selected.
Yeah.
So I guess the first question before we dive into each one individually, why might employers explore alternative visa options? other than an employee or someone not being selected.
Right. So that they can have an alternative option to keep the employee employed, hopefully within the United States, even if the H-1B cap isn't selected. Now, not every employee is going to have an alternative, but certainly now is a good time to start having those conversations because we are halfway through registration, and then as soon as registration is completed, we're going to start knowing, hopefully, again, by March 31st, who's selected.
Gotcha. Well, let's jump into the alternatives off that and start with the F1 OPT STEM extension. So essentially, moving forward, I'm just going to have a couple questions regarding each alternative. So first question is, what are the benefits of the F1 OPT STEM extension?
Certainly. So the benefits are just 2 additional years of employment authorization that allows for additional time to be submitted into the CAP for a selection process. And so it's allowing for companies to retain the employees that they would like to retain, continuing training those. Those are recent graduates, so they are just most are typically, first jobs out of college or postmasters or post PhD degrees, and just really getting their feet wet within the U.S. economy and U.S. employers, and hopefully getting that investment. If you've already had somebody work for you for a year, you have an additional 2. Again, more opportunities to apply for CAP and look at alternative options as well, and just making sure that you've got a full scope as to what's going on.
Okay. And what are some eligibility requirements outside of students holding a STEM eligible degree?
Sure. So the employer at the location where the employee is employed needs to be an E-Verify employer. And the employee also needs to complete with his or her manager and then the school a training plan that will be verified by the university throughout the 2-year process to ensure that the milestones that were anticipated at the beginning of the 2-year STEM extension have been completed at the end. So there is some additional work from a student, the student or employee perspective, and then also companies.
Okay.
For most of the clients that I work with really have their employees who are on F1 STEM OPT really take the lead in managing that, because that's a direct coordination with the DSOs at each university where they graduated. So it makes sense. Certainly if companies want to have more support, there's a variety of ways to help support companies during that.
Cool. So next, moving along, we have the J1 visa, which is a unique alternative. So what are the benefits of the J1?
J1s are situations where there's internships or training. There are some specific limitations, and there are other types of J1 visas out there.
Okay.
The world that we typically work in are trainees or interns, and there are going to be some limitations. Somebody who just graduated, who has been working at your company for, say, now they're on their 3rd year of STEM, probably not going to be able to pursue this option. However, you may find yourself in a situation where it makes sense to have somebody come over as a trainee or intern, depending on the circumstances. These are very much controlled by the J1 sponsors, and those are usually nonprofit organizations that have a certain number of allotted J1s each year. It's a very extreme vetting process. The sponsors that I've worked with take their designation very seriously, and so it is important. Again, much like a training program for the STEM that needs to be met and followed up on, it's very similar in this instance as well. So the J1 sponsors are going to be following up. They're going to expect a plan in place, and just with the understanding that these are not long-term, they're not generally extended. And then also there are certain J1s where you do need to, or the foreign national, the foreign national J1 trainee or intern will actually have to go home and live for 2 years. That's the 2-year residency requirement. So it really is a more limited circumstance.
Yeah.
Certainly it's a lot more flexible if you're eligible for the F1 OPT STEM extension, but it's certainly an option to consider if you're looking at alternatives.
Gotcha. Okay. Great. So moving along, we have the L1, Intracompany Transferees, and there's, I guess, 2 branches within the L1. So we're going to start with the L1A. Sarah, what are some benefits of the L1A?
Well, there's not a cap like there is an H-1B cap, so there's not a limited number. However, without there being a cap, there's also some certain basic requirements that need to be there, which include the individual foreign national employee must have worked at a related foreign entity abroad outside the United States for at least 1 continuous year in the preceding 3 years in a managerial, executive, or specialized knowledge capacity, and then will ultimately be coming back in the United States for a manager executive capacity position. So that would actually potentially be some prospective planning from an employer standpoint. I've worked with a lot of employers who have higher level individuals who just graduated with, say, a master's degree and have worked there for 3 years and have worked their way up, sending that individual abroad to work for a foreign affiliate for at least a year, getting international experience, which is pretty typical in this day and age, particularly with multinational corporations. So it could actually fit within company business plans, even though the idea was to get an H-1B. But sending an individual abroad, having them learn more about the company in a foreign entity, and then bringing them back after a year or so, depending on the circumstances.
It's pretty unique and cool. And
it certainly is. It allows for ongoing development. It allows for that when you're investing in a high-level employee, or even, or any employee for that matter, because the general goal is to retain the employees that you hire, right? Right. At least in my opinion, you're getting that return by actually offering an employee an opportunity. Obviously, it is also disruptive. So again, there's always the flip side of the coin where it is a little disruptive. Planning and living abroad, maybe not in the home country, but into a different country, depending on the circumstances, can always be a bit disruptive. But it's certainly an option for the multinational corporations out there. Right.
And as a follow-up, with the L1A, are there any dependent benefits? First time I'm using that word. I guess, so quickly, what would a dependent be in this situation?
A dependent would be a spouse or child under 21 years of age. Not the spouse. Spouse would be over 21. Child must be under 21 years old. Spouses can work. And so, but there's a caveat to that. So they can enter the United States in the dependent status, which is L2. Then they would be eligible to apply for work authorization once entering. So it's not exactly the same process as it is for the L1A. But it's still a benefit of this particular visa category.
Cool. Then the second part of this is the L1B. And how does the L1B differ from the L1A?
So there are some similar requirements. You have to have worked in a foreign, outside the United States, affiliated entity for at least 1 year in the preceding 3 in a managerial, executive, or specialized knowledge capacity position. And then you're coming in to the United States in a specialized knowledge capacity. So that information that is particularly unique within the industry or within the company that has made you essentially a subject matter expert. That's how I look at it. Those individuals that are being ultimately selected for their subject matter expertise, particularly when it comes to company, say, processes or products or procedures, that need to be brought in so that they can disseminate their knowledge in the United States. So it'd be similar where maybe you have an individual who's graduated and has worked for the company for several years, has some knowledge in the United States, and you'd like to pair that knowledge with, say, another foreign affiliate who has, developed parallel but not quite the same, get them the expertise there, then with the ultimate company goal of bringing them back to the United States to disseminate the foreign information or the international information to the United States. And so it is, again, it's strategic, it's prospective, it's looking forward, and it's also allowing, again, an opportunity to have an outside the United States work experience. So getting that, again, as I just said, it's quite popular these days, but it's also then disruptive because if it wasn't in the initial plan because the plan was an H-1B and now you have to uproot your life, that is something to take into consideration, but it is potentially an option for multinational organizations. The key differences between L1A and L1B from a longevity perspective, L1As are valid for 7 years, so any time spent in the United States is counted against that 7 years. Any time spent outside, you can add on in the end, so recapture that time. For L1B, it's 5 years. And so that is something to take into consideration. L1Bs are actually shorter than H-1Bs. H-1Bs have a validity of 6 years. There are certain exceptions to that. The exceptions that apply to H-1Bs don't apply to Ls, and so they are a visa that is very useful tool, no cap, certainly bringing in knowledge from foreign entities that are affiliated, subsidiaries, parents, etc. So they are a useful tool, but again, they can be disruptive if that wasn't the original plan.
Gotcha. Great. So moving along, we have the O1 visa, typically for people who possess extraordinary ability in the sciences, arts, education, business, and athletics. Almost seems straightforward. Is it as straightforward as the description? It
is if you have a Nobel Peace Prize, certainly. I have yet to run into that. One day, fingers crossed. These require a lot of work. They particularly require a lot of work from the O1 individual that you're sponsoring, because you have to demonstrate that you essentially are a star within your field of expertise and are well known and are acknowledged as being a top scientific researcher, as a top basketball player, as a top professor in your field. And so it's not just, oh, I have an advanced degree, I qualify for this. It's so much more. Now, there are multiple ways of evidencing this. So if there are press articles written about you because of the business success that you've had or the research that you've completed and the findings that you have, there are a variety of ways to demonstrate why you would qualify for this. But this is certainly one that is the scrutiny is high, and the documentation and information necessary to demonstrate that you meet the qualifications also high.
Gotcha. I imagine then a lot of foreign athletes here in the U.S. and are one of the major 4 leagues may be on an O1 as a result.
They could be, yeah. They could be. There are some other alternatives for athletes and the like, but your top stars, certainly this would be, I can imagine this would be discussed with their immigration counsel.
Yeah. Great. So moving along, next we have the E2 treaty investor. So I guess starting off, who is eligible for the E2?
E2s are specifically designated countries that have treaties with the United States. Ones that I've worked with in the past, France, so a French-owned company that has a subsidiary or affiliate in the United States or is opening a subsidiary or affiliate in the United States, such that the ultimate parent is French-owned. What then happens once you demonstrate the significant investment into the United States is that they can bring individuals who hold French citizenship to the United States to fill managerial, executive, or essential positions in the U.S. Much like the L and also the J, I don't think we mentioned that, spouses can actually apply for work authorization as well. However, unlike the L, in this situation, there isn't a work requirement, so you don't have to have worked with the French parent company in this example for a year before you would qualify. You would just need French citizenship, and then to be able to demonstrate that your job fit in with one of those categories.
Okay, great. And moving along, we have the E3. Australian specialty occupation, and one of the eligibility requirements is Australian citizens only.
Correct.
So what are the benefits of the E3 and how does it differ from, I know they're different, but how does it differ from the E2?
So they're both based on treaties, but in this instance, it's solely for Australian citizens, so it doesn't have anything to do with who the parent company of the of say the U.S. organization is.
Mm-hmm.
It doesn't have to be an Australian parent company. You just have to be an Australian citizen.
Gotcha.
And then you would ultimately be able to come into the United States, assuming you're offered a specialty occupation, so much like the H-1B. So the position being offered to the Australian citizen
Mm-hmm.
would be a specialty occupation, a job that requires at least a bachelor's degree or its equivalent in a specific or related field, and the individual Australian, him or herself, has that specific degree or one in a related field. Oversimplifying, yes, just given the level of scrutiny. However, those are the basics, and it's certainly a useful tool for individuals who are from Australia.
Yeah.
And certainly is one that is available year-round, and so it allows for a certain level of flexibility.
Gotcha. And the annual cap has never been met, as I understand?
Yes. So it's certainly a great situation where you have, you know, if you're from Australia and you want to come to the United States and you've got a job offer from a U.S. company, this is certainly a useful tool.
Definitely. Great. So moving along, we have the TN visa.
Mm-hmm.
What are the benefits of the TN? And I guess, so we'll start with the benefits and then the eligibility requirements.
Sure. So the benefits are there's no cap. Not that the cap hasn't been met, it's that there was no cap at all.
Okay.
There's an indefinite amount of time. You just have to demonstrate that you have the intent to return home, whether it be to Canada or Mexico at the end of your tenure. And it's 3-year increments. So it's a really nice amount of time for the TN. Also based on a treaty, between the United States, Canada, Mexico, but a little different. Some of the items that you have to look out for are the fact that unlike an H-1B or an E3, there are very specific professions that are included, and so you have to fit within one of those professions. And if you don't, then you would have to look outside of the TN. But this is certainly a useful tool. I think from a process perspective, Canadians probably have it the easiest. What they need to do is show up at the border, present the petition, and they can typically enter within a couple of hours in TN status to be work authorized. If you're a Mexican citizen outside the United States, you would have to go to the U.S. consulate to obtain a TN visa stamp in your passport before entering the U.S. So it's certainly a useful tool. There are some limitations, but there also is quite a bit of flexibility.
Right. You mentioned that it's there's one of the eligibility specific specialty occupations. Can you just, I think 3 or 4 occupations?
Sure. So there is management consultant, there's engineer, there's scientific technician, technologist, there's statistician. Those are some just examples of professions.
Gotcha. Great. Moving along, we are now on the H-1B one. This is another visa reserved for specific citizens, correct?
Correct. So H-1B ones are specifically for Chilean or Singaporean citizens. I've yet to see this cap maxed out as well, and it's very similar to the H-1B and E3, where you have to be offered a specialty occupation, so requirements of at least a bachelor's degree or its equivalent, and the individual Chilean or Singaporean citizen must have that equivalent or related, or that specific degree or related degree. Again, oversimplifying it a little bit, but for those individuals who are born or have citizenship in Singapore or Chile, it's certainly a viable option and allows for that level of flexibility to come into the United States and have an alternative if the individual is a recent college graduate and has not been selected for the cap and no longer has F1 work authorization.
Gotcha. Great. So to recap, we discussed some visas that allow for work authorized dependents. Can you recap what these visas are?
Sure. So J, L, E, those are the areas where you're going to be able to get work authorization as a dependent, spouse, and then J's allow for a little more flexibility with that.
Gotcha.
So that's one of the perks of those particular visa categories.
One we have one on here that we didn't have a dedicated slide for, but the H-4. While we're on topic of that,
right.
What's the H-4?
So the H-4 is a dependent of an H-1B non-immigrant. So somebody who's already entered into the CAP or works for a CAP-exempt employer, and an H-4, their spouse specifically. So all dependents are known as H-4 dependents, but spouses specifically can apply for work authorization after a certain point or points of the permanent residency process has been completed, and the H-1B and his or her family members are just waiting to file for their green card. This is a hot button issue. We expected an update in March of 2020. It's March of 2020. So, which time has flown in 2020.
Yeah.
I can't believe it's March. But we're looking at a situation where the current administration has said they want to pull this benefit back, and we are waiting to see if it ultimately will be pulled back, and then what will ensue after that, right?
Definitely.
So it's certainly an option that is currently available, but the caveat being it has been a goal of the administration since the administration, assumed office to move forward and get rid of this benefit. It's hard to get rid of a benefit once you grant that benefit. DACA is still around, and so we're just looking at circumstances where everybody just needs to be in the know that if you have this benefit, you're working to this benefit, fantastic, but just being mindful that things may change depending on the announcements out of the administration or rewriting of regulations and things like that.
Definitely. And that's going to lead us to the final slide in this main presentation. We can't forget about global. There may be a global alternative option.
Right.
Now, we won't go too deep into it, but what is what we're calling global parking, and why might a company explore this?
Sure. So I mentioned L1 previously, where you have a multinational organization that has entities throughout the world, not the United States, the world, but let's assume they're also in the United States too, right? As is, they're being employed in the United States right now. It's having that flexibility with affiliate subsidiaries, parent company, etc. That's the L. With global parking, there are some companies that may just be U.S. based and they don't have the option. And there are companies out there, in particular in Canada, where this is an option, where you can actually send your employee to be a contractor for Canadian organizations and essentially work for the U.S. company, but abroad in Canada.
Yep. Great. And we have a couple of webinars on that. So if you want to check out our webinar library for more on global parking and those types of options, feel free to check those out. Great. So Sarah, as we near the end of today's presentation, what are some practice pointers for our employers currently in attendance? We compiled a list of questions that we typically see. So I'll start with number one. When should I start evaluating other visa options for my sponsored employees?
I would recommend that you speak to counsel now to look at alternatives for those individuals. From a prioritization perspective, everybody's a priority, but I would certainly prioritize those individuals whose work authorization expires prior to October 1st, because that just helps from a prioritization standpoint. Again, I understand and appreciate all employees are a priority, but that's how, if you have not started the analysis yet and you want to get started, that's how I would look at it.
Gotcha. And how do I know which alternative is best for my employees?
Well, I think that's a multi-layered analysis. I think that is definitely a deeper dive and conversation with your immigration counsel to look at the options, the benefits of, say, sending somebody abroad and what that ultimately does. I think you have to get hiring managers involved. You potentially have to get recruiters involved to understand what, and maybe even, higher level business leaders who have a good understanding as to what the strategic plans are for your company over the next, say, 1 to 5 years. Like, does it make sense to move this individual abroad and make that investment based on what our business goals are? So that is a we're going to leave it a little high level there because we
sure.
can get into the nitty gritty and everybody would probably hang up by the time we finish that conversation. So it's one of those things where looking at the best alternative is not just looking at it from an employee perspective, but also from a company perspective as well.
Okay.
And my guess is that's where the analysis would start. And then ultimately the decision will be made on how moving the employee or determining the option, what's going to be best for the business is what's going to be offered to the employee. That's how I would look at it.
Okay. Third question that we typically see, if my employee isn't selected in the lottery, do I still have time to explore alternative options? Absolutely.
How much time is going to be dependent upon when the employee's work authorization currently expires. That's what it will come down to. So again, going back to point one, if you have not evaluated, now is the time to start and prioritize with those individuals whose whose work authorization expires, in particular prior to October 1st.
Okay. And finally, is there ever a time when an alternative should be considered before an H-1B?
Potentially. I think that you just want to take a look at what your business goals are. I've often, when reviewing individuals, had the alternatives presented to them up front. A lot of time I can tell you that this is more of a employee manager conversation. H-1Bs are certainly a useful tool for not only companies, but also for foreign nationals. And so there are certain employees who say they're Canadian citizens and would specifically qualify for a TN, but the employee specifically asked for an H-1B, and employers have accommodated in circumstances like that. So say you have an individual in the United States in L-1B status already, and this is a strategic decision. So it really depends on the circumstances and the employee, him or herself.
Gotcha. Great. And to cap things off, just a reminder that technology can help determine alternatives. For example, employers can screen foreign nationals as potential employees by sending visa assessments for legal review. And that's going to end the main presentation. We have been getting a couple of questions from the audience. We'll get to those in just a few seconds. But there are just some final housekeeping slides that I want to cover real quick. First, we have a couple of upcoming webinars. Two of them next week. We're going to be going over our 2020 Immigration Trends Report and discuss 6 emerging trends. And then 19th, we're going to be discussing coronavirus implications for employers to consider. There's a 30-minute briefing type policy update type webinar. Hope you can join us. Sarah and I will be discussing some travel updates that have been coming out and whatnot. And then, as I mentioned at the beginning of the hour, March 25th, we'll be going over Q1 policy updates. And as always, be sure to subscribe to our mailing list so you can receive these latest webinar invites, as well as follow us on the major social channels so you can be aware of the latest news updates as they come out. And then finally, we have SHRM and HRCIA continuing education credits. Again, these will be emailed out tomorrow afternoon. But if you'd like to take a second to copy these down, please feel free to. Okay, so Sarah, I guess so a couple of these questions are very specific. We unfortunately cannot answer those. Please consult your immigration counsel for further information. But I am curious, of the alternatives, which permit path to permanent residency?
That is certainly a determination that is, and a discussion that is one that you need to discuss with your immigration counsel. Very clearly, I think one of the reasons why students in particular like the H-1B is there's flexibility in changing employers. So they're not necessarily locked into an employer, but there's also a very clear path for being able to extend H-1B status beyond the 6 years and if you started the permanent residency process. So that is definitely a discussion to be had with Immigration Counsel to understand what the options and limitations are in certain circumstances based on the particular non-immigrant work authorization that the employee is in the United States.
Gotcha. And I think that is going to be it. Unfortunately, a lot of these questions are, as I mentioned, a little too specific. We can't discuss. So again, as Sarah just said, please discuss with your immigration counsel. Great. So I would like to thank everyone for joining us this afternoon. We'll give everyone 4 minutes back in their day. As a reminder, this recording will be sent out tomorrow afternoon, as well as the slide deck. Thank you for joining us, and have a great rest of your afternoon.